around the globe. It doesn't matter what country or what culture. And those children who are being adversely impacted by their parents' parental conflict. So currently, there's also programs in South America and some of the more developed countries that are beginning to use the guidelines. So can we advance to the guidelines? Yeah, okay. So the National Parenting Coordination Guidelines were initially developed in 2002, 2003, and published in 2005. We now have, as of 2019, an international set of parenting coordination guidelines. There is one other set of guidelines that is available that was written for and by psychologists that was published in 2012 by the American Psychological Association. The international guidelines have been published by the Association of Family and Conciliation Courts, and they are for all disciplines. So there are this set of guidelines, which I will go over in some detail today. I believe Elena and colleagues are working to get them translated into Italian so that they're a bit easier to access. But this now provides our guide for how to do parenting coordination, what's proper, what the process is, what the beginning is, how we use it effectively, how we work with extended families, and so forth. So I will review those. If you have questions, please do write them down. I will be happy to try to answer any questions about that. I know these guidelines very well. Along with my task force, I wrote them. So they have been approved now by the governing boards. So the purpose of the guideline really was to provide clear direction for parenting coordinators, lawyers, judges, courts, mediators, any professional who's working with families, to have a guide for how to use this intervention, how to use parenting coordination, and to provide some basic guide for the type of training that is required to do this type of work. So it was not only to be a guide for practitioners, but for jurisdictions like yours to know how to introduce a program, how to develop a program that fit with your laws, that fit with your culture, that was unique, because Italian family law is different than Spanish family law or other European country, and certainly different than the United States. So the process of parenting coordination has to be adapted to work with the families that you work with and the laws that you work with in your court. So there we go. The additions to the guidelines, some of the main differences have to do with the level of guidance. If you read or were familiar with the guidelines published in 2005, there were a lot of mays, meaning it was sometimes clear, sometimes not so clear. That's changed. What we have now is we have a lot more shalls, we have a lot more shoulds. The reason we have that level of guidance has to do with research and what we've learned in about 20 years of practicing parenting coordination. There's also a definitions section And they've been organized in a way to try to clearly identify content or topics and to have expanded training modules, because we had 4 before and now we have 8 in a lot of detail. So what will also be available later this year and in a special publication in 2020 is a complete literature review on all the relevant social science, a compendium of statutes, rules, governing authority across jurisdictions around the globe, relevant case law impacting the practice, as well as a resource on several sets of international guidelines. Spain, for example, has developed their own set of guidelines. So there's resources that can be shared around the globe as you're developing your program. So the guidelines are listed here, and I'm not going to just read them for you. I'll go over them in a little bit of detail. The first guideline has to do with competence, and suggesting that the parenting coordinator should have very specific experience and training in order to undertake the work. For example, most parenting coordinators either have a legal background, or a lawyer, or they're a psychologist, or a social worker, or other mental health professional, and they have family mediation training. In addition, it's recommended that they have extensive experience working with families in high conflict. These families that need or utilize parenting coordination tend to be the highest conflict individuals, and therefore the level of experience needed to work effectively is extensive. The family mediation training in most jurisdictions is required to meet the minimum level of competence. And in addition to training, family mediation training, training in the process of parenting coordination, understanding family dynamics in separation and divorce, what we know about families who are not in so high conflict and families who are in very significant conflict, the dynamics that are related to parents when they were never married, because some families are made up of individuals where the mom and the dad never had a romantic relationship. They never lived together. They share a child, and that's about all. And so working to develop an effective co-parenting relationship with those type of families is very different than a family who's had a romantic relationship, who's already established some sense of co-parenting alliance. In parenting coordination, we see all kinds of families, and so understanding the difference in the dynamics becomes an important component of knowing what type of intervention you need to use to be successful. Child development knowledge is also required, understanding basic developmental steps, what's normal, what's not normal, how are children impacted when their parents separate or when they're exposed to conflict. All of those things come into play as a parenting coordinator. Intimate partner violence training, or domestic violence training, is also required. As you know, families in conflict don't always limit their conflict to words. They often will express their conflicts through violent means. either through actual physical assault or harassment or financial intimidation. There's many ways of engaging in intimate partner violence, and a parenting coordinator needs to have that training and experience, because you will run into those dynamics. Child maltreatment and other issues related to the safety of individuals in the process, the parents as the children. Ethical considerations pertaining to the process are covered. Diversity, and by diversity, we don't just mean cultural diversity, race, religion, gender, identity. We have families that are made up of, are very diverse these days. And so the need to have some sensitivity and awareness of how to be respectful and still work effectively with the families. Co-parenting without a hyphen, and what I mean is the co-parenting alliance, the dynamics, the triangular relationship that we know from social science to be effective. We have been able to develop techniques to help develop and build that co-parenting alliance, to provide that scaffolding for the child to grow and grow well. And as Elena mentioned at her introduction, the use of technology is becoming much more prevalent. Online software co-parenting programs, means for communication, means for sharing information. And because I practice mostly in the United States, some with domestic families, but also international families, the geographic distance between parents and the parent and child is quite large. And so the only practical way to have a parenting and coordination appointment is by software, electronic means, a web meeting, and so forth. So that's become much more prevalent than it was when parenting coordination started 15 to 20 years ago. Okay. So part of what is considered minimum level of competence for a parenting coordinator is, in addition to the things that I've just mentioned, is to have an understanding of the relevant laws as it applies in your jurisdiction. What are you able to do? What will the court enforce? What will the court order? How to use the court as a partner in this process is an essential piece of using parenting coordination effectively. In many jurisdictions, more now than ever before, parenting coordinators are being given the authority to make some decisions for parents when the parents cannot decide. This varies greatly depending on the laws, but if you as a parenting coordinator are going to be making decisions for the parents, whether they're small, non-substantive, or they are larger, substantive decisions, you need to have training in decision making. So when we talk about decision-making authority, it doesn't mean an arbitrary process. It's a specific process for making a decision that's there. If your jurisdiction does not allow any decision making, then the process of parenting coordination will look a bit different, because parenting coordination by and large is reserved for those parents who either cannot or will not make decisions effectively for the best interest of their children. And so the parenting coordinator steps in to serve in that function in order to protect the children and facilitate the children's lives. The arbitration is in the United States is differentiated from decision making. Arbitration is binding, meaning that the parenting coordinator has the final word. That is allowed in some jurisdictions, not all. In most jurisdictions, the parenting coordinator has decision-making authority. Parents can still go back to court to have the judge review the parenting coordinator's decision in most jurisdictions. In some, no. Once the parenting coordinator decides, it's done. So the second has to do with impartiality. A PC shall maintain impartiality in the PC process. That does not mean the parenting coordinator is neutral. They are not neutral when making decisions that impact the best interest of the children. So the parenting coordinator is not to be biased, partial to one parent or another, but they are an advocate for the child. They are to be the voice, the advocate for what is in the child's best interest. So impartiality in the guidelines is defined as freedom from favoritism or bias in word or action, but not in terms of who do you advocate for. You're advocating at all times for the child or the children. There's specific guidelines about impartiality now, specifically referring to gifts or favors, diversity, not misrepresenting what your training is or what the outcome could be or what a court could do. How do you approach a case and build the trust with the parents in order to be effective and not show favoritism or bias? One of the problems that's faced often when a parent is unhappy with the parenting coordinator is they will file a grievance with a licensing board or like an oversight.
You mean to understand much
like where you get your
context? What?
Where do you get your license from? Your authorization to practice.
Okay, depends on. We don't have as a PC.
But
we have
like
just
it's a
as
mental
social
health
worker,
or an
psychologist.
attorney. Yes.
Yeah. We have a national kind of national association, but they are compulsory. You can decide to enter or not.
So they would complain to this association to file a grievance against you. You have to defend yourself. One of the common complaints is impartiality, that you have been biased. Whether you were biased or not, but it's a complaint to try to get you off the case. They don't want you to work with them anymore because they don't like your decisions. And so this is why there's much more extensive detail given in the guidelines for impartiality now than was there 15 years or so ago. So that's some of the reason and rationale. A conflict of interest. There's also a specific guideline about conflict of interest. A parenting coordinator should not serve in a case that will create a conflict of interest. This is when you have previously served in a role with the family. For example, I'm a psychologist. I'm also a custody evaluator. I'm also a parenting coordinator and a family mediator. So if I had served as the custody evaluator in a case, and the family wanted me to be the parenting coordinator, that is forbidden. That would be creating a dual role, and that would be considered a conflict of interest. This is another common complaint, at least in the United States. It's a means of filing a grievance, a complaint against parenting coordinators. When I have a case where I did therapy for one of the parents' family members, a sister, many, many years or so ago. And I've had no contact with them. But I get a new case, a family parenting coordination case, and they want me to take the case. It has a different name. I don't know. I don't recognize the surname. And sometimes I may begin the case and not realize I've had contact with them in the past. This kind of conflict of interest would be prohibited based on new guidelines. So it's much stricter to try to preserve the integrity of the parenting coordination process. If you do identify a conflict of interest, there's now very specific guidelines for disclosing. An example, I was working with a family and discovered that the father owned a company that did mowing the grass, lawn maintenance, for my building. And I had employed him, his company, to mow my grass at the building. I did not know him. And once I discovered, then I had to disclose. I disclosed to the family. They had the option of saying, we don't want you to work with us. They also had the option of saying, we understand, but we don't think it will create a conflict. And they can sign what's called a waiver, saying that this is, sorry, you get all sorts of notices here. So that would be an opportunity for me then as the parenting coordinator to decide, should I proceed or should I not proceed? In this case, the family wanted me to continue. And they agreed to sign. I agreed to continue, but I didn't use the father's company anymore. I had to terminate services with the company in order to do that. So that's an example. Well, I couldn't do both. It was a conflict of interest. So that's an example of where you may find yourself kind of in a sticky spot, and so you have to figure out, how do I proceed? And the guidelines about conflict of interest is intended to give much more detail for those type of circumstances. Another area where conflict of interest arises has to do with referrals. As we'll talk about in a few moments, one of the interventions that's most effective in parenting coordination is the support team, who you use to assist you in helping stabilize the family. Sometimes, often, I need to refer one of the children or a parent to a psychologist or a psychiatrist for mental health treatment. I cannot refer to individuals who work for my clinic. I have a clinic, and there are psychologists who work in my clinic. That would create a conflict of interest. I need to refer outside. I cannot provide any other services while I'm serving as the parenting coordinator. I can't supervise the exchange of the children. That's considered a conflict. So the specifics about the different roles, the different potential conflicts is detailed in this new guideline as well. Multiple roles is another guideline that has been greatly enhanced, and there is consensus. We've gathered data, not only in North America, but from around the globe, about the parenting coordinator prohibition against serving in a dual or a multiple role, even with the consent of the parents. So this is prohibited. The clarity on this comes from research and experience in the effectiveness of parenting coordination. Because when a parenting coordinator compromises the integrity of the process by serving in a dual role, it undermines the likelihood of success for the parenting coordination. The parenting coordinator is usually serving in a facilitation, mediation role and not a decision-making role. So there's two roles to differentiate within the process. Ideally, the parenting coordinator will help parents reach a mutually agreeable decision between themselves. Sometimes they will not or are not able, and then the parenting coordinator switches to a decision-making role. That role between facilitating and decision-making is fluid. It goes back and forth. Facilitate, sometimes I decide. I try to facilitate, sometimes I have to decide. At all times, I revert back to facilitation. Why? Because I'm trying to empower the parents, help the parents be independent in their decision-making as parents, as a co-parenting unit, rather than me serving as a third parent as a part of their family. That's not my goal. That's not my role. My role is to empower them to do so. Otherwise, I just become a third-party professional decision maker for them. It's not practical, and it's not helpful for the children ultimately. But often, families come into parenting coordination, and you have to make some decisions to get the process started. Otherwise, you cannot be effective. You have to start there. So sometimes in the beginning, I'm making more decisions than I want to make, just to get a plan, a parenting plan, to make a decision about the children, school, or extracurricular activities. But as quickly as possible, I am reverting to a facilitation role. So when we talk about multiple roles, dual roles being prohibited. That's not what we're talking about. When I talk about a dual role, I'm talking about if I were a custody evaluator and then I were a parenting coordinator, or I was a therapist and then I were a parenting coordinator. So the difference between the functions within parenting coordination between facilitation and decision making is a part of the process. That is considered to be an effective part of the process. If you are authorized in your jurisdiction to make a substantial decision for the parents, an example might be healthcare provider, physician, pediatrician, or where the child will go to school. That, for many families, would be a substantial decision. That requires notice, meaning you have let the parents know I'm no longer trying to facilitate this. I'm going to be making a decision about whatever the issue is, so that the parents are clear when you are moving fluidly between facilitation and decision making, because it is not always clear to the parents. It may be clear to you, but it may not be clear to the parents. And so a part of informed consent is letting them know. And in some areas, this is happening more and more in the United States. Parents, you have to let them know in writing. You have to give them a document that shows that you are moving from facilitation to decision making. Confidentiality is one of the big issues in parenting coordination. The parenting coordinator shall inform all participants on the limitations on the confidentiality before the process commences and throughout the process. In 90% of the jurisdictions around the globe that have been surveyed, parenting coordination is a non-confidential process, meaning it generally does not carry the same provisions of confidentiality or privacy that may accompany family mediation. There are some exceptions to that, but I'm just going to talk about the majority of jurisdictions which are non-confidential. So there's 3 types of confidentiality that are identified and need to be clarified within the process in your jurisdiction. Elena, is it non-confidential here now?
Yeah. But
Yeah.
it's not, there is not a legislation, so it's more than a decision that is made by professional and
By the parenting coordinator?
Yeah, by the parent coordinator or with some court. We made a kind of guidelines, but more informal than formal. So,
Okay.
Yeah,
But-
yeah. Usually it's not confidential about what's happening in the parenting coordination.
Okay.
Yeah.
So this may be important for you to think about, particularly as you are developing your program and the legislation is yet to be developed here in Italy. 3 types of confidentiality for consideration. Confidentiality outside the process is called external confidentiality. Inside the process, between the parents and the parenting coordinator, between the parenting coordinator and the child or children, is internal. That's the internal part of the process. External refers to the parenting coordinator having communication with the court or with the lawyers for the parties. That's considered to be external part of the confidentiality process. The third type is called liminal. That's liminal confidentiality. That is with collateral sources or team members. So there's 3 different types to think about and to identify how you plan to handle that in your program. In most jurisdictions, it is not confidential internally, liminally, or with the team members or support members, or externally. But it varies. So, my home state of Florida, I'm from Florida, it is a confidential process between the parenting coordinator and the court, with exceptions. It is not confidential with the parents or the children or any of the team members. So it's kind of a mixed model. And most courts, jurisdictions, have to carefully consider how to handle that based upon your laws. Exceptions to confidentiality globally tend to fall in the area of mandatory reporting, child abuse, intimate partner violence, assault, those type of areas that are mandatory to report don't fall under the confidentiality. Those are considered to be exceptions to the confidentiality. Even in areas where the scheme is non-confidential, the parenting coordinator is expected and required to keep records private.